Instead of setting up a land tribunal, a division was set up in the High Court under the Environment and Land Division. When the new constitutional dispensation came up, the Committee of Experts recommended the establishment of an Environment and Land Division.
Why?
To enhance the faster dispensation of land matters.
Yes. Now, okay. So it is expeditious disposal of land matters.
My Lord, that is one of the reasons. One is to ensure, apart from expeditious handling of land matters, is to enhance access resolution of disputes, proportionate resolution of dispute, and the just resolution of disputes.
Yes. If we overuse this chance, tell us what you will do to accomplish, to satisfy those requirements.
Thank you, my Lord. One is to ensure that I have control of my courtroom by way of time management and case management. What this would entail is, one, ensuring that matters that appear before my court have complied with all the requirements. This is the witness statements and all the requisite pleadings. And when carrying out pre-trial, is to ensure that you can minimize the issues. The other one is to encourage parties, if it is not a matter that is very contentious, they can decide to adduce evidence by way of documents only.
Very well. Yeah. So is you're going to be very, very firm on case management?
Yes, my Lord.
And the hearing.
Yes, my Lord.
Now tell us about eviction. Section 1, I believe 159G of the Land Act requires that an eviction involving a group of people, government representatives should be informed. Why do you think that is important?
My Lord, the reason why it is important is because the people who are supposed to be evicted require to be protected, their properties to be protected because of human dignity, right to life, and also the marginalized. In this sense, we are talking of women and children who probably will be involved in the eviction.
Thank you very much. Honorable Eji.
Thank you, Chair. Madam, would you distinguish between public, private and community land?
Yes, Honorable Eji. Public land is land that is owned by the public, and it involves, one, unalienated government land, two, community land that cannot be determined whether it is community land or land belonging to private persons, three, it is land that belongs to state departments or state parastatals. It is also land that entails water, minerals, among others.
All right, go on to the second one.
The second, on private land, is land that is owned by individuals, and it is freehold or leasehold. The third one, community land, is land that was in the previous Group Representatives Act. It is land that is registered as community land, and it is also land that is utilized by a community for cultural practices, shrines, and for grazing rights. It is also land that is trust land, that is not public land. And community land belongs to persons who come from one ethnic group, geographical area, or cultural background.
Thank you. Are you familiar with environment impact statements? Environment impact statements? An environment impact statement, are you familiar with that phrase?
I'm not familiar.
Do you know NEMA?
Yes, I know NEMA.
What do they do?
NEMA is an institution that carries out the processes of licensing people who want to carry out various activities, and the licenses would be for maybe if you're carrying out water activities.
Why is that important?
The importance is to protect the environment as per the principles of environmental protection.
Right, madam, you're now a judge. How would you promote judicial independence and accountability?
Judicial independence, my lord, is on two levels. As an individual, in making my decisions, I would make my decisions without fear, without favor, without inducements from parties, and without inducements. And I would ensure that my colleagues who we not handle matters together with, we are of the same status, do not influence me in making matters in
And as an institution of the judiciary?
Institutional of the judiciary is provided for under Article 160 of the Constitution, and it provides that the judiciary should conduct its services and work in a manner that is in accordance with the Constitution and the rule of law. The judiciary also has a judiciary fund.
Fine. Accountability?
Accountability, Honorable Attorney General, entails where, as an individual or even as an institution, you are accountable to the people of Kenya whom power is derived from.
Where is that in the Constitution?
Accountability is provided for under Article 10 of the Constitution and Article 232 of the Constitution.
Thank you. Thank you, Chair.
Thank you, Commissioner DCJ.
Thank you, Chair. Excuse me, I have been running a cough. The ELC court, the ELC, give us one judgment you're familiar with that has been given by the court you want to join on protection of the environment, or indeed by any of the other hierarchy of courts.
Thank you, my ladyship. The case of Kenya Association of Manufacturers, which was a case that dealt with flat plastic bags, and it dealt with a right to clean and healthy environment and public participation.
How far did that go? How far?
Yes, my ladyship. The matter was determined, and what the court held was that Kenyans had a right to a healthy and clean environment.
Did it go beyond the ELC? Was there an appeal?
To the best of my knowledge,
you're not aware?
Yes.
What is the utility of precedent in, let's deal with land since that's where you want to go. What is the utility of precedent in deciding land matters?
Thank you, My Ladyship. The importance of precedents is to assist the courts who are lower than maybe from the Supreme Court, Court of Appeal of a higher standard than maybe the high courts, to guide them in making decisions and to guide them.
Does it not restrict free thought? Does it not restrict the independent thought of independent judicial officers, judges?
My Ladyship, as a country we are governed by common law principles, and if a matter is determined by a court of the superior record, if it is the Supreme Court, we are bound by the decisions of the Supreme Court. If it is the Court of Appeal, and the various benches of the Court of Appeal have determined the matter in a different way, then you can adopt the decision, you can make a decision based on the facts that are before you, the case that are before you, and the various decisions of the Court of Appeal.
What if inside yourself, and you think you're a very good judge, inside you really don't agree with this judgment, okay? You're bound, but you don't agree with it. How would you deal with it? What's that exercise called? You're bound. It is a decision of a higher court, and you're bound. But that's not the way you would interpret the law yourself. What could you do, and with what result?
What I would do is to make the decision based on the binding decision from the higher courts, but I would make my reservations in the judgment, but I would be bound by the decision.
That's correct. Those reservations are called what? That's the word I'm looking for. You're already there, but what are they called? That is very well done. Let's get closer home. You joined this institution, and oh, I'm being told to tell you what that word is. It is called distinguish, but you still are bound. You must stay with the law. This institution has been looking at itself from inside, and saying, we could do better if we did this. Are you aware of just a single thing the institution has done to improve itself?
Yes. The institution, the judiciary, has the Sustaining Judicial Transformation Framework, which has been able to guide various courts. And in the court that I intend to join, I know they have practice directions which have been able to guide matters in the ELC court.
I wish you very well. Chair, I thank you.
Thank you, Commissioner Wasame.
Thank you, Chair. 2 questions.
Yes, my lord.
Once a mortgage, always a mortgage.
My lord, what this means is that once you have taken a mortgage on a property, then the institution cannot stop you from redeeming that mortgage. And it is a principle of equity.
Okay. When can somebody qualify to be within the category of innocent purchaser for value? When can you use that defense?
An innocent purchaser for value would be used as a defense if the person whom that property maybe previously belonged to is alleging ownership of that property, And what this innocent purchaser for value would say is that they didn't have notice that this property had been acquired, say, irregularly and procedurally or in a corrupt manner.
Okay. I wish you well. Thank you, CJ.
Thank you.
Thank you, Commissioner Machanza.
Do you know the case of Mitubel Welfare Society versus Kenya Airports Authority?
Yes, I know about it.
You are aware the High Court made a decision?
Yes, I'm aware.
And the Court of Appeal made a decision. Are you aware?
Yes, I'm aware.
What did the Court of Appeal say about remedies seeking to the kind of remedies the court may issue in terms of protecting socioeconomic rights?
What I'm aware, the Court of Appeal said that the people who are supposed to be forcefully evicted from a property have a right to protection from the courts. They have a right to life. They have a right to dignity. And they need to be given notice. And to the best of my knowledge, the decision of Mitubel is what informed the amendment of the of the Land Act in respect to evictions.
Okay. Are you aware of the Convention on Wetlands called the Ramsar Convention?
My Lord.
Okay. Are you aware of any treaty that protects the environment that is applicable to Kenya?
Yes, I'm aware.
Yeah. Give me one and why you think it is important.
I know of the treaty, the Paris Treaty, that was signed, and it applies to the Climate Change Act in Kenya.
Okay. Finally, how does international law, apart from conventions, apply to the laws of Kenya?
Under Article 2 of the Constitution, Kenya can ratify treaties and instruments, and they apply to us. And then 2, the general principles of international law are applicable.
Thank you.
Thank you, Commissioner Njeru.
Okay, 3 questions. You are appointed as a judge of ELC, and somebody comes under certificate of urgency in respect to a dispute over a warehouse which has been leased to him for a period of 3 years, but a dispute arises between him and the person who has leased the property to him over rent, and also over a breach of some of the tenancy conditions. How would you determine that matter if it comes to you under certificate of urgency?
If it is a lease for a period of registered lease,
it's a lease of 3 years, registered or not registered, but it's a 3-year lease. It's a warehouse, and they've disagreed, and he wants certain protection from you, and that's why he has come under certificate of urgency. How would you dispose of the matter?
if it is a 3-year lease, I would presume that it is not registered, and this is a matter that will not be dealt with by the Environment and Land Court. This is a matter that will be dealt with by the Landlord and Tenants Act.
Sorry, the landlord?
Landlord, tenants, catering, shops.
Which forum now then will deal with it?
The tribunal, Landlord and Tenants Tribunal.
Okay. What do you call it? That tribunal?
It's a rent tribunal.
All right. Now then, business premise rent tribunal. Now the next question I would want to understand from you, could you define to us what an easement is?
An easement is where a dominant owner of land requests a servient owner of land to give them a right of way to utilize a portion of land in the servient land.
Okay. Now my final question relates to trusts. Now, Benami trusts, could you define for us what they are, and upon definition, whether they are legal in our jurisdiction?
A Benami trust is a trust where you allow another person to hold property on your behalf. And in Kenya, it is deemed to be a constructive trust, because that is a common law trust. And it has been decided, I believe, in the case of Kitilit, where a constructive trust arose.
Thank you, Commissioner Deche.
Thank you, Chairman. Council, the commissioners are in receipt of your sample ratings. They are all submissions on matters that you handled. 3 of them are of ELC. 1 is arbitration on a tender matter, and 1 is an election petition. And they range from 2014 to 2018, and they are all well written.
Thank you.
The reason we call for them is to assist us evaluate you on your communication skills, and I can say that you communicate well in writing. I'll ask you just 2 questions.
Yes.
In one of your sample ratings, you are dealing with the issue of land ownership on the issuance of title, validity of a title issued. This is a case of Mary versus Olive. Let me not mention their full names. Maybe they are watching you on Facebook. But in that case, it's dealing with the issue of validity of title. Now, recently, the last 1 month, 2 courts have said something about the validity of title and our registration system. That is the ELC in the petition on the Ruaraka issue. And there is also the bypass matter in the Court of Appeal, where in a majority decision with one of the judges dissenting, and he said something to the effect that in our a title under the torrent system of registration is defeasible when you can prove mistake or fraud or illegality. So both decisions were addressing the issue of the torrent system of registration. Can you tell us what the principles of the torrent system are of land registration?
Thank you, Commissioner. The torrents principle of land registration are 4. One is the mirror principle. What the mirror principle entails?
No, just name them. You don't have to
There is the
explain.
mirror principle. There is the insurance principle. There is the indefeasibility principle. And there is the curtain principle.
Thank you very much. My next question: if you became a judge of ELC and someone came and told you, presented a case in court that Fort Jesus has been allocated to a private individual, what would be your thoughts legally, not the emotional thoughts, your legal thoughts on the issue? On the face of it, would that be legal or not? And if it's not legal, what law would it have contravened?
Fort Jesus is, in my opinion, a property of importance it belongs to the public.
Let me rephrase the question. What public land is not available for alienation to a private individual? Under the Land Act.
In my opinion...
No, under the Land Act.
Under the Land Act.
Yes.
Under the Land Act, public land cannot be alienated unless certain procedures have been followed.
Okay, you can look that up. There is land where no matter what you do, you may not alienate it to a private individual. And I wish you all the best, Anne. Thank you, Chair.
Thank you.
Thank you, Commissioner Pichoi.
Sorry.
Thank you, Mr. Chairman. Council, good morning again.
Good morning.
Yes, earlier alone you did respond to the Honorable Attorney General on the various principles, particularly in public service. You referred yourself to Article 232 and you talked about accountability. Can you share with us 3 more values that guide state officers under that article?
Under Article 232, we have efficient and economic use of resources.
2.
We have public participation.
Public participation. Okay. Can you reflect on number 1, effective and efficient use of public resources, and share with this commission what is your understanding of that value?
To my understanding is that as a public officer, we are bound by the Public Finance Management Act, which provides that we need to utilize resources that belong to the government in an efficient manner without waste.
Okay. Good. My last question. I've seen from your write-up that you have served in the Committee on Devolution of the Law Society of Kenya, and you have also given legal education to county government or county government stakeholders. In your view, and this you feel free to share with the Commission, what is the biggest challenge facing our devolution, in particular the county governments, and how would you be able to address it?
In my opinion and in my view, the county governments have put up proper laws that are in place, but the biggest challenge is corruption.
Corruption. So could you share with us at least how do you address corruption?
In the judiciary?
No, in the county government.
In the county government?
Yeah.
One is to have checks and measures. This would entail maybe educating the employees of the county government on the ill effects of corruption. 2 is probably recruit officers, integrity officers, who can be able to work in the institute, who are employees of the institution, but the integrity officers, so that they can monitor and even probably report to Kenya Anti-Corruption Commission.
Okay. Thank you, Mr. Chairman. Thank you, Council.
Thank you, Commissioner Mugenda.
And I have 2 questions for you. Demonstrate to us and through very tangible situations that you have the leadership skills that required of a judge.
Thank you for that question, Commissioner. The leadership skills that I have acquired is that I set up a law firm about 8 years ago, and that requires a lot of stamina. And I've been able to run it successfully. I have good interpersonal skills with my employees. I have shared with them a vision of what I want for the firm, and I've been able to influence them to buy into that vision. So I would say I'm a visionary leader.
Anything else apart from your law firm which is successful? Any other tangible?
Yes, I serve in 2 boards in my church. One is called Philemon Half House, which is a board where when prisoners leave prison, we house them. I sit in that board. So we house those prisoners before they are released into the society. And the decisions we make in that board, I would believe, would require somebody to be an influencer and also to have a positive impact in the community.
My second question, Anne, is if you're successful, then maybe you'd be one of the young judges, which is a young woman judge. You have people before you who are rude. They're not respecting you. They think that maybe you don't deserve or whatever they think. How would you handle a situation like that in a court session?
In a court session, I believe a court is a court of respect. It is a court of decorum. And you must be in control of your courtroom and be firm.
So what would you do in that scenario? You know, there are people in front of you, they are shouting, they are rude, maybe they even want to come after you. What would you do?
If that happens, Commissioner, is that if the court is unruly, is one, you would probably give them a warning. And if the escalation continues, then you would adjourn the matter, maybe for a period of, say, 30 minutes, for the tempers to calm down. Then thereafter, you come back and resume court. But I believe firmness is very key for any judge. One must be in control of their courtroom.
My last question, Anne, is please tell the Commission the part of the Constitution that deals with diversity, and what does it say?
Diversity is provided for under Article 232 of the Constitution. And the importance of diversity is to ensure that we have inclusivity, we have the face of Kenya.
Okay, I think that's good enough, Anne. Thank you.
Thank you, Commissioner Kosue.
Thank you, Chair. Wakili, I have two questions. One is on community service. I've gone through your CV and you have not indicated whether you participate in community service. I'm sure perhaps you do. In what ways have you contributed to the community?
Thank you, Commissioner, for that question. I have participated in various activities in the community. In the public sector, I have been able to give legal aid, free legal aid, pro bono legal aid. 2, I have been able to give legal advice to Baringo County government. Thirdly, I serve in my church community, 1 in the Philemon House Ministry, and 2 in a school board in the church.
Thank you. My second question is on what is happening now. The education system in Kenya is being transformed from the known 844 system to CBC. What is CBC and how is it different from 844?
CBC is a competency-based system of education, and what it entails is imparting knowledge, skills, and competencies on the children, and for the children to impart this knowledge, skills, and competencies into real-life situations.
Any other difference? The difference between 844?
The difference between that system of education and 844 is that 844 was mostly and purely based on examinations. Yes.
Okay, thank you very much. Thank you, Chair.
Thank you, Commissioner Minde.
Thank you, Chair. Now, Anna, supposing you are successful and you become a judge, then you will be a state officer. Under Article 232 as a state employee, would you then consider yourself to be a public resource?
Yes, I would.
Why?
I would consider myself as a public resource, given that the power has been given to me by the people of Kenya to serve them. And I will be serving the people of Kenya.
Okay. So now that you're a public resource for the people of Kenya serving in the institution of the judiciary, how then would you utilize yourself as a public resource to ensure an efficient, effective, and responsive use of yourself for the benefit of the people?
As a judicial officer, one, I would start my court sessions on time.
Timeliness, two.
Two, I would ensure that I communicate on my judgments again on time. Three is to time. Delivering my judgment on time. I would ensure that I would also be able to cater for people who are marginalized when they come to my courtroom.
Look at the word responsive. How would you ensure that the justice you deliver is not only efficient and effective, but it's also responsive to the needs of the people of Kenya as per their ideals when they establish the institution of the judiciary in the Constitution? What did they want, and how would you conduct yourself and your whatever it is they've given you to do on their behalf to ensure that everything that you do is responsive to their needs? Timeliness, yes.
One is timeliness. Two, I would ensure that I serve the Kenyans with equality, without fear and favor. Serve with impartiality. Have integrity. Be independent without being influenced by other parties. And I believe free from corruption.
Thank you very much.
Thank you.
I wish you well.
Thank you.